Welcome to Dorsey & Whitney's webinar on PPP loan debt forgiveness, lost in a black hole. I'd like to introduce Jamie Watley, our program moderator, Dallas office co-head, and a partner in the Finance and Restructuring Group. Jamie?
Great. We have a wonderful program set for you today. The program is 60 minutes. Materials and attendance forms can be found at events@dorsey.com. If you need attendance for today, please feel free to email attendance@dorsey.com. We will be answering questions using chat. Time permitting, we'll try to answer all that come in at the end of the presentation. If we don't get to your question, you're welcome to contact any of the panelists or your trusted Dorsey contact after the webinar. We have a great lineup of speakers today. Doug Lang is of counsel in the Commercial Litigation Group in our Dallas office. He spent over 16 years with the 5th District Court of Appeals in Dallas, authoring more than 2,100 opinions and working on 6,100 cases. He's perfectly situated for any SBA appeal issues that you may have. Ken Logston is a partner in our Finance and Restructuring office in our Utah office. He represents banks and borrowers in lending transactions. He's advised many borrowers as well as assisting many lenders in helping their borrowers with obtaining PPP loans and working on forgiveness applications. Kirk Schuler is a partner in our Commercial Litigation Group. He's in our Iowa office. He focuses on dispute resolutions. He has also helped many borrowers with PPP related issues and is perfectly situated to help with appeals. Next, our presentation today will cover 3 different areas. PPP, what it looked like in the past, a short history lesson to catch us up on where we are and how we got to where we are and what the loan, applying for loans looks like. PPP present, applying for forgiveness, what forms to use and how to complete the loan questionnaire. PPP in the future, appealing adverse decisions, preparing for audits and False Claims Act. Really, the questions that you're going to ask yourself are you prepared? Are you ready if there's an SBA review or any adverse decisions, appeals, or SBA audits? And are debt forgiveness applications really actually being processed? I will turn it over to Ken.
Thank you, Jamie. Before we dive into the application process, it's appropriate to give a pretty quick background. It's going to be really high level. As many know, this is a very complicated program. It's been now fully implemented over a year. But going back to March of 2020, when the COVID-19 pandemic was just starting to affect the economy, Congress passed what is known as the CARES Act on March 27, 2020. The Paycheck Protection Program, or the program as I'll call it, was implemented under the CARES Act, but it took actually several days before it got off the ground. It wasn't until April where money started to move. Part of the complexity of the program is the fact that it's essentially being layered over the top of Small Business Administration regulations, or the SBA. And there was some wisdom in doing that, actually. At the outset, there were some criticisms. About the choice for Congress to layer this program in over the SBA regulatory landscape. But as we saw with the Main Street Lending Program, it was actually a rather wise decision. It was able to be implemented relatively quickly. Under the Main Street Lending Program, the alternative funding, if you will, and loan source under the CARES Act, it didn't get off the ground for many, many months. And there was still a lot of complexities and unanswered questions, even when that program came to an end at the end of last year. In any event, because of that, this program has been guided by many rules and FAQs. Right now, we're sitting at 67 FAQs that have been published by the SBA over the last year, and they're ongoing. We still get new questions and answers as recent as just a few weeks ago. I think it's also important to talk about some of the iterations of the original program. We'll call it either the first wave or round 1. It was modified quite a bit in June under the Paycheck Protection Program Flexibility Act. It changed the cover periods from 8 to 24 weeks, the maturity dates from 2 years to 5 years. It changed the requirements for payroll expenses to be no less than 75%, but actually 60%. In any event, under the second wave, it's interesting to note that the first wave, or round one, is back in operation. Companies that haven't taken advantage of round one can now take advantage of round one as well as round two. I think it's also important just to highlight just briefly the material differences between round two and round one. I mean, one being that a company who wants to take advantage of round two would have to have also taken advantage of round one, of course, and fully spent those loan proceeds towards permitted uses. Also, there's a tighter threshold with respect to the employee size. One, it was 500 or fewer, or the alternative standards set out by the SBA. Under round two, it's 300 or fewer employees, and there is no benefit of that alternative standard set out by the SBA unless you fall within a few categories that are excluded, namely the restaurant hospitality industry, some nonprofits, and even the news business industries. The loan amounts are different. Under round one, it could be a loan amount not to exceed the lesser of 10 million and 2.5 times payroll expenses of the company. Under round two, it's now set at $2 million, not $10 million. And there's an exception for 3.5 times monthly expenses for the hotel, food industries and hospitality industries as well. On the next slide here, we're going to be taking a look at the overall numbers. Now, thankfully, just as of yesterday, we have new numbers. Currently, to date, under the program, both round one and round two, a total of just over 780 billion has been funded. That leaves really roughly just under 30 billion remaining, and it will be open until the end of May. So there's still money there to be had for companies that are looking at either round one or round two. Under round one, it's over 5 million loans. There's over 525 billion advanced, and the average loan is over 100,000. If you look under round two, it's not a surprise that the average loan is only 77,000. It's targeting a smaller group of companies, and that's obviously evidenced by the fact that instead of it being 500 or the alternative size standard or fewer employees, it's now 300 or fewer employees. And right now, there's an additional 4.6 million loans that have been advanced. You can see the group is a little smaller. The companies are generally smaller. Next slide. So now you have the loan. Will you be granted forgiveness? And that's the real question, right? I think most companies, if not all of them, there's a few exceptions, went into the program expecting to take advantage of full loan forgiveness. There are a few that haven't done that. They decided to treat it as a very low cost loan, but for all practical purposes, we're going to be focusing on the forgiveness side of the equation. So steps to debt forgiveness. Obviously there's an application that needs to be completed and materials provided. The lender has 60 days to review the application and submit it to the SBA. And the SBA has 90 days to review and return its decision. That's one area that we're getting a lot of questions on because there's many, many applications out there that are beyond the 90-day period. And it's still a lot of question marks as to what that, frankly, we don't really know. Because due to the sheer volume of the applications coming in and the size of the program, the SBA is overwhelmed. And so it's very difficult for it to adhere to that standard. On the next slide, it's appropriate to kind of break down just briefly the components of the application. You're going to have to, calculate the amount to be forgiven. The 60% rule is that no less than 60% must go towards payroll costs. The covered period is either the 8-week or 24-week period that is chosen by the company for purposes of when those costs are paid and incurred, either or. That was a clarification earlier on in the program. There's also a salary and hourly reduction calculations and full-time equivalent reductions. In cases where companies had to reduce hours or reduce workforce, there were some modifications to the amount that could be forgiven with some exceptions, of course. And then the supporting documentation that needs to be provided. For lenders that are processing these applications, the SBA has signaled that they need to just do a good faith review of the materials that are required, and then can rely on the borrower certifications. This is a pretty interesting component to this program, because you would argue that perhaps it sets a relatively low bar for lenders. And even under the program, however, it doesn't seem that it would excuse clear error. But as we get further on into the program and into the loan forgiveness application process, I think the lending community, really does need a little bit more color around this. There is some guidance out there in the world that's non-SBA related, and bear in mind when it comes to the potential focus of fraud and abuse of the program, to date, it's almost been exclusively focused on borrowers. In time, perhaps, though, we'll probably see a shift to a focus on some of the lenders that have participated in the program. And I think a good analog to that is the Fair Housing Administration Loan Program, where the Department of Justice has used the False Claims Act to actually pursue lenders under that program. And my colleague Kurt Schuler will speak more to that, the elements of the False Claims Act. But there is this understanding, and I think it would be appropriate for lenders to be mindful of, to the extent they have knowing, any knowledge, they know of any information that would make a borrower ineligible for loan forgiveness, they need to be careful. Lenders are part of the loan forgiveness application for a reason. They have to be the first party to sign off before it's sent on to the SBA, and there's some responsibilities that go along with that. Importantly, a lot of lenders have also lent to their own customers, and when they have their own customers that also have a PPP loan, they tend to have anti-money laundering programs in place and requirements that adhere to the Bank Secrecy Act in general that could allow for a bit more information, right, within the institution, within the lender group, to make a determination about certain facts. And so lenders need to be mindful of facts they might have of a borrower that might lead them to conclude that perhaps they're ineligible. So those are the types of things to be tracking as a lender. There are standards out there, though the SBA seems to be signaling that they're not going to be very focused on it. It doesn't mean that other departments of the federal government are going to take a closer look, and they may very well do so. Well, next slide, please. Okay, so let's go ahead and jump into just briefly there's two areas really when it comes to eligibility. I mean, clearly there are issues around companies that were in an industry that weren't eligible to begin with. For example, gambling companies and so forth. So there are excluded categories, but when it comes to focusing on eligibility, other than those check the box items, the two areas of probably the greatest ambiguity, one is the affiliate question, and that's a very complicated analysis of how large a company was at the time of obtaining a loan under the program. And if not done properly, eligibility could be questioned and therefore determined that the company wasn't eligible because it was too large. And so we're not going to dive into the affiliate rule analysis. That could be a seminar all its own, but we will talk a little bit more about the necessity question, because that was also a very important component to the application process from the outset of the program. Where there was a great deal of ambiguity, and we believe remains. And that particular certification is found on the loan application, the initial loan application. And the borrower must certify that current economic uncertainty makes the loan request necessary to support the ongoing operations of the applicant. When this first came out, there was a great deal of confusion. And so the FAQs jumped in front of that and started to address this directly, and ended up creating these two different categories of loans over 2 million and loans under 2 million. Now that's 2 million over when you aggregate with affiliates, so keep that in mind. And the SBA simply said, look, if your loan is under 2 million, we're going to deem that certification to have been made in good faith, more or less giving loans under 2 million under round one a free pass. That did not say that other governmental organizations would take a closer look. That's still a potential, and we'll talk about that later on in this program. Those over 2 million will be subject to an automatic audit, and we'll talk about that a bit as well. But importantly, some recent developments have included even loans as low as 150,000 or greater, where the company has used gross income to calculate its PPP loan amount. So it's kind of that category of those being audited and subject to this review has been broadened quite a bit. Again, there's no guarantee that another agency won't pursue any kind of enforcement action. There's False Claims Act that we'll talk about. But in any event, the guarantee by the SBA will not be affected by any determination that this particular certification was not satisfied. All right, so as for the questionnaire itself, those that are over 2 million will receive a loan necessity questionnaire. Both for-profits and nonprofits will get very similar looking questionnaires. And there's several questions that break down essentially the need for the company or the organization to obtain the loan. The rule is that must be supplied by the lender upon receiving a loan forgiveness application, and it must be completed and returned by the company or the borrower within 10 business days. The consequences of not making that deadline remain unclear. It does say in the questionnaire that there could be remedies by the SBA for failing to do so. But these are questions that truly speak to kind of a snapshot of the financial health of the companies and organizations, both pre and post application. There's still a lot of ambiguity around what answers are going to trigger a deeper dive, so to speak. I think it's being seen by the industry. This is a very efficient way, ideally, to tackle the onslaught of loan forgiveness applications of loans over 2 million, to sift through quickly which ones need a deeper dive. And so if you're a company getting a loan questionnaire, be thoughtful about your responses. We would suggest that we reach out to your counsel to actually get some additional guidance around those responses, because it could impact the way your file is reviewed later on. And that is a brief summary of the history and the loan application process to date. And with that, I will turn it over to my colleague, Doug.
Thank you, Ken. Well, you get the SBA final decision. You get the letter from the SBA directly, or the borrower or the lender gets it, and the lender will pass it on. And either you get good news, it's forgiven, or the borrower will be told you were ineligible to begin with. So you are not forgiven, or you were ineligible for the amount that you were given in your loan. And then there's a question of eligibility for any forgiveness as to the amount received. One of the critical issues is what Ken was talking about here, the loan necessity. Looking back to when the application was made, and then looking at what happened subsequent to that. So the next slide goes into what now? Of course, you have a choice. You can comply with the decision of the SBA if they say you're not going to get forgiveness for whatever amount, less than the whole or all of it, and then work it out as to what your payout is at your low rate of interest over time. Or you can pursue the administrative appeal. This is a critical time because you must file your petition for review with the SBA's Office of Hearings and Appeals within 30 days after you get the SBA final loan decision, either directly from the SBA or from the lender. But this is something that you are going to have to really hurry to get ready for. 30 days. I'm going to go into in a second what you've got to do in that 30 days, what you've got to do to get ready. It's critical that anybody that believes there's a ghost of a chance that they're not going to be forgiven any part of the debt or all of it, that they need to get ready. They need to really have everything in readiness to pursue that appeal. Now, for the lender, this is important as well. I want to make that clear. As Ken pointed out, the lender on the PPP loan may also be the lender on a conventional loan with his borrower. If the lender could be in a conflict situation here. If the borrower is not able to pay the loan, if they're going to be in straits, how are you going to deal with that? So you need to be very careful, both as the borrower and as the lender, to look at all those ramifications. The only issues on appeal on the next slide are going to be, was the borrower ineligible? And was the borrower ineligible for the amount received or for the use of the PP loan proceeds for unauthorized uses? And I'll talk about that piece in a minute. And is ineligible for loan forgiveness, under some other program, and is ineligible for PP loan forgiveness in any amount when the lender has issued a full denial decision to the SBA. Well, think about authorized use for a minute. As Ken pointed out, this is typically payroll related, salary. It's going to, the 60% rule is implicated. But what about if the borrower buys new equipment or repairs equipment? This could be an issue with the SBA. You may have read situations where the borrower did such things as buy a new Gulfstream aircraft. That's going to be a problem for them. Let's talk about the standard of review. If you file this appeal, what do you have to show this administrative law judge once you file that appeal in 30 days? The ritual language is the SBA loan review decision was based on clear error of fact or law. And the borrower, appellant, has the burden of proof by a preponderance of the evidence. Now, what does that mean? Let's look at the next slide. We don't have a clear meaning yet on what this clear error is. There's some other cases out there that talk about it. One is this Concrete Pipe and Products of California case. A finding is clearly erroneous when, although there is evidence supporting it, the reviewing body on the entire evidence is left with the definite and firm conviction that a mistake has been committed. Well, that's almost as clear as mud too. But the point is, if the SBA made a clear error, they got the facts wrong, for instance, they just didn't get it right, or they're looking at totally inconsistent factors, you have to be ready to deal with that. You have to be ready to point that out. Now, let's look at what the petition on the next slide, next couple of slides, are required. You've got these federal regulations that talk about this appeal process, 13 CFR 134.1202 and the others. It requires that 30 days, and we're not talking about 30 weekdays or business days, 30 calendar days, you have to file this petition that goes into very specific detail. You have to demonstrate jurisdiction. This was a PPP loan. And you have to show that the appeal was timely filed. You have to provide with a copy of this, a copy attached, the SBA loan review decision that's being appealed. The next one is critical. A full and specific statement as to why the SBA loan review decision is erroneous, together with factual information. This is not going to be a two-liner. This needs to be very specific. And then what relief is sought. If you have a partial denial, you want a full denial. If that's, a full allowance of the loan. The next slide demonstrates some very confidential information that has to be supplied. Payroll tax filings actually filed with the IRS and the state. You must present those as an attachment, even though you may have given them to the SBA to begin with. but you've got to provide those. The next one is also very confidential, the next category on the next slide. Signed copies of the federal tax returns actually filed with appropriate schedules. Now, the next next slide is going to alert you to the fact that what about this information that you're attaching to this petition? It's supposed to be confidential and not subject to anyone finding out outside of this process. And that is the regulation that specifically says it. I'm skeptical of that. And you can seek a protective order from the administrative law judge to protect this information from anybody getting a hold of it. And that's something that you should always consider, is to protect your confidential information from piercing eyes. The next one, please. Okay, this is real litigation, folks. This is not some laid back administrative process where it's casual at all. This is the real thing. The administrative law judge reviews what's called the record. And interestingly, that record is submitted by the SBA shortly after you file your appellate petition. The SBA is supposed to dump into that case before the ALJ and give you a copy of everything, or the relevant documents, that is, that they relied on in making their decision. If the borrower, the appellant, is not satisfied with that, there must be an objection lodged in 10 days. Then the record closes in 45 days after filing the appeal. So that's a real short period of time, meaning you really have to hustle and have everything ready. Now, what if you want more information and you think the SBA may not have dumped everything into the record? Next slide, please. Generally speaking, the administrative law judge will not permit any form of discovery. But if you believe it's appropriate, if it's necessary, you should consider making that type of application before the ALJ. There's a real question there about whether you're getting all of the information and whether you get due process if you feel that you are being stonewalled to some extent. Next slide talks about the ALJ's decision. Well, the decision is supposed to be handed down by the judge 45 days after the record closes. Remember, the record closes 45 days after you file your petition. Then you have 45 days after that where the ALJ is supposed to consider it and make his or her decision. But those last two words at that first point, as practicable, tell you that there's some room there. If the judge is overwhelmed, they do get more time. They will file findings of fact and conclusions of law, supposed to be detailed. Now you can see those on the Office of Hearing and Appeals website, part of the SBA website, about how they write those opinions. Now, I checked again this morning and I didn't find anything on PPP loans at this point. They're still working their way through if they indeed are in litigation. But the decision is final when 30 days have elapsed after the ALJ actually files that opinion. However, next slide. You could ask the ALJ to reconsider the decision within 10 calendar days after the decision is rendered. The request for review by an administrator at a higher level must be filed within 30 calendar days. And that is a prerequisite to the last step, which is the suit in federal court to try to turn it around. Now, this could all take, as we said, 90 days, but I would count on it being a very arduous situation and very difficult.
Great. I'll turn it over to Kirk.
All right, fantastic. Thank you, Jamie, and thank you, Doug, and Thank you, Ken. It's a pleasure to be on the panel here. I'd like to welcome everybody to, I guess, the second half of the presentation, the webinar. And this is potentially where the black hole gets a little darker, I guess we could say. Before I start to get to that darkness, let me just point out that we know there's lots of great questions in the chat. Jamie is monitoring that, and we're all monitoring that. We've got some great questions I see there, and we'll get to those. So fortunately, we're running, it looks like probably a little ahead of schedule even. So I'll be able to wrap up the final section of this webinar, and then we'll have some time for these questions at the end. So, you know, thus far, we've talked about the background, kind of the past, the history of this PPP program that started over a year ago. And right now, kind of the immediate past, immediate future are the forgiveness reviews that a lot of the borrowers maybe on this, viewing this webinar right now are going through. Maybe some have just recently received a decision, or some are still waiting for that decision, as many are. And that's kind of the current landscape. What is also happening though, in the offing are what we call SBA audits and even government investigations. And we've seen a little bit of this thus far. There's been some rumblings of audits maybe currently happening. And certainly there's been some government investigations early on. You know, last year, there's a lot of criminal investigations and indictments that hit the news. And I'm sure a lot of you got wind of those. But what I'll focus here on my part of the webinar is what we expect to see in terms of audits and government investigations moving forward from now. So if we move to the next slide, we're going to talk about SBA audits first. And, you know, a lot of the viewers today may be a little confused. Well, you know, thinking that, well, the SBA is reviewing my loan right now. So what are you talking about an audit for? Isn't that the same thing? And there's a real, we're not surprised by that confusion. There is a lot of confusion about that. The laws that Congress has passed and the interim final rules, the regulations, they nevertheless talk about reviews and audits. So we have to think about these separately. And the SBA reviews that Doug was just talking about in terms of when a borrower gets a final review decision from the SBA, that's the decision that you can appeal. That's the decision that's being made now at the forgiveness stage. That's one type of review that the SBA is doing, but the law allows the SBA to do another type of review, and that's these SBA audits. And this is an opportunity, as the slide says, for the SBA to review and question again the certifications and eligibility of the borrowers. And then it potentially jeopardizes, of course, again, the loan forgiveness for such borrowers. And as Ken had mentioned earlier, these audits are going to be mandatory for all borrowers above $2 million. As part of that audit process, and also mandatory for the $2 million borrowers, will be that loan necessity questionnaire form. Now, there may be some borrowers on the webinar right now that are less than $2 million borrowers, but you may have actually already received a loan necessity questionnaire. It appears that that's a normal process that the SBA is doing through the forgiveness review process too, which also leads to the confusion as to, is there any difference between this forgiveness review and the audit? So just because you've received a loan necessity questionnaire, it doesn't mean that you're undergoing a formal audit. You may still be in the forgiveness review stage. But you can rest assured that, well, I don't know if rest assured is the right word, but you can be certain that if you're above $2 million in terms of a borrower, that you will have to undergo this audit, and that you will have to fill out that loan necessity questionnaire. And so what do we know or don't know about these SBA audits? Well, that's on this next slide that I'll provide to you on the screen now. So if we go to the next slide there, this SBA process, there's really not a lot of clarity, unfortunately. We don't know what the definition of an audit even is. There's not an indication of when these audits will even be performed. We suspect that there's audits going on now. We suspect that there's going to be a whole lot more audits happening in the future. As far as timing goes, at the very last bullet on this slide, it notes that we expect up to 6 years before the audit program is concluded, and that's because the regulations talk about this time frame, that borrowers need to hold on to their documents for the 6 years. And so really this audit process could take place anytime between now and 6 years, but as far as when that happens, nobody really knows, and nobody really knows how broad or what the scope of these audits are going to be, or even whether they're going to be on site at the company, the borrower's company, or whether they'll be just performed remotely. And it's also interesting. Let me back up. So typically, the SBA audit process would be expected to be completed by the Office of Inspector General. The SBA, just like most all agencies, has an OIG's office, and that Inspector General is in charge of auditing the agency and making sure that there's not fraud, waste, and abuse taking place. And so it would be expected that the OIG, the SBA's Office of Inspector General, would be in charge of conducting these audits, but we don't truly know if that's going to happen. The regulations and the law just hasn't made that clear yet. And what we do know through the interim final rules that have been handed down in terms of the appeal process that Doug just explained is that the decisions of the Office of Inspector General from the SBA are not appealable. That's plain and simple, black and white, right there in the appeal rules that Doug discussed earlier. So I would expect that these audit results are not going to be appealable, but even that is not perfectly clear. You might be in a situation, even as crazy as this could be, that you go through the forgiveness review and you even do an appeal of whatever that forgiveness review concluded, and then you have a final answer through that appeal. And then within the next 6 years, you have an audit. And that audit, particularly, if it's being conducted by the Office of Inspector General, they may come to a different conclusion, even a worse conclusion, and the borrower would have no recourse in that circumstance, according to the regulations currently on the books. So it's a bunch of unknowns right now as to what these audits are going to look like. We thought we were going to have some clarity just after Christmas, a little gift to all the nerds like us that follow this stuff, because the Consolidated Appropriations Act that was passed on December 27th, enacted into law on December 27th, it had the Economic Aid Act as part of that. And the Economic Aid Act said that the SBA, the administrator of the SBA, was supposed to submit to the Senate and House committees within 45 days of December 27th, so around Valentine's Day, a audit plan that was to be submitted to Congress to detail exactly how this audit process was going to work. And then the law was even better in the sense that 30 days after that, so every mid-March, the Ides of March, April, now into May, we would be getting reports from the SBA administrator that was explaining how this audit process was functioning and how it was working and what was going well and what wasn't working. But we haven't received any of those reports or the audit plan. And maybe it's gone through back channels through Congress and it's just not public. But there's just literally, a black hole surrounding that issue. So if we move now, we're going to transition from the audit process into a little something that's even darker, perhaps. And that's when a forgiveness review or even an audit leads to a False Claims Act investigation. And this is a practice area that I am involved in here in Dorsey. We published a False Claims Act blog, and we've been following this very closely, and that is the interaction of the Paycheck Protection Program and the False Claims Act. And this area, unlike the audits where we haven't received a whole lot of clarity from the SBA yet, the False Claims Act is an area where there's a little more clarity and at least a whole lot more history behind it to kind of guide the analysis. And so this slide here where it says 1863, that's not another SBA form that's part of the Paycheck Protection Program. That's actually the year the False Claims Act was enacted. It was in the middle of the Civil War during President Abraham Lincoln's administration, and that's why it's called the Lincoln's Law. And the rationale for the law at the time was to target unscrupulous government suppliers who were defrauding the Union Army by selling them, sawdust instead of Springfield rifles. And so the basis for the act, or the purpose, was that you could prosecute suppliers that were submitting claims for payment to the government based on goods that were never actually delivered. And although the False Claims Act has been in existence now for 150 years or more, it was seldom used because it wasn't particularly robust at the time. And that changed at least by 1986 with the passage of the False Claims Reform Act. Senator Grassley, actually right here in Iowa, he's kind of considered the father of the modern day False Claims Act, and he was the one that proposed that bill. And ever since 1986, the False Claims Act has been more of a factor in all government interactions for government contractors and anybody like borrowers or like lenders in the PPP program that are now interacting with the government for payment, such as these PPP loans. So let me go into a little bit of background or basics about the False Claims Act. So if we go to the next slide here, the False Claims Act today, not what it was in the Civil War, but today it covers a whole lot more than just submitting false claims for payment for sawdust instead of Springfield rifles. And it can cover, there, as you see on the screen, not just false claims, but false statements. So if you're making false statements on any of the paperwork that you're submitting to get a false claim paid or approved by the USG or United States government. And it can also apply to when you're concealing an obligation to the United States government. Now, this is an interesting aspect in relation to the PPP program, because if you're failing to return an overpayment, such as a loan, if you were applied for a loan, you received a loan, and then through the forgiveness application process, you did not repay what you were supposed to pay back, well, that could be concealing an obligation to the United States government and possibly a violation under the False Claims Act. The statute also has some robust conspiracy provisions and then retaliation provisions. So if someone is reporting a company for violating the False Claims Act, what we typically refer to as a whistleblower or a relator, they're protected by the law and you can't retaliate against them, of course. These key TAM and relator provisions are also a huge part of this law, and that's what really started to change in 1986 as well, with the amendments and more recent amendments as well, making those provisions more robust so that not just the government could bring these actions, but private citizens could bring these actions on behalf of the government. Of course, the whistleblowers that are within the company are the ones that know what, are the ones that are closest to the issues and perhaps the false claims. And the law, of course, encourages whistleblowers by, providing for attorneys' fees for their counsel. So it's encouraging their attorneys as well, and it's encouraging them in the sense that they can share from 15 to 30% of the recovery that is able to be recovered from bringing one of these actions. And the penalties for a defendant in a False Claims Act are very, very steep. Not only do you have mandatory treble damages for the loss, but you can, but civil penalties are imposed, and accounting for inflation, that can now go up to $23,000 per violation. Okay, so let's bring this False Claims Act now back to the Paycheck Protection Program. So on the next slide, we'll see, if we fast forward now to 2021, how does the False Claims Act come into play now? Well, it can apply really at these, or the pivotal points are these 3 points that are on the slide. At the time that the borrower applied for the loan, the time that a borrower is applying for forgiveness, and then anytime you're additionally communicating with the SBA about the loan, and that could be the loan necessity questionnaire that we already talked about. And so at all of these times, there's potential risks involved where a borrower could incur liability for a false claim, depending on what they're reporting through these communications to the SBA. So let's break it down a little more detail. The next slide, we're going to talk about the actual application form. Ken, you may have heard when he spoke earlier, he talked about the economic uncertainty certification. That's part of the application form itself. All borrowers are going to sign off on that, and you have to certify that your loan was necessary. And that's going to be scrutinized. And the SBA's and the government has made it clear that that will be scrutinized. Fortunately, there are some safe harbors. You may remember over a year ago that the government said, well, hey, if you pay back your loan by May 18th of 2020, we're not going to question you. That's a safe harbor, so we're not going to question whether it was necessary. If you decide you made a mistake and you pay it back by May 18th, that's a safe harbor. Well, there's now additional safe harbors effectively where a first draw borrower, if you learn during this forgiveness review process that the SBA is deemed you ineligible for all or part of your loan, and you pay that back, that operates as a safe harbor, and the SBA won't be referring you to further investigation to the OIG or the U.S. Attorney's Office, and that could really help in terms of avoiding False Claims Act risk. Now, for the second draw borrowers, the application form to be eligible for a second draw, the safe harbor is actually kind of built in already because you have to certify that there was a 25% reduction in gross revenues. And the SBA said, well, hey, if you meet that, then it was necessary. And so we're not going to question you there. Now, of course, if you make a false statement that you're not, there wasn't actually a 25% reduction in gross revenues, well, that could be just a false statement, and you could open up yourself to False Claims Act liability even then. But otherwise, there's that built-in safe harbor for the second draw borrowers. Now, if we move on through the process to the next slide, where we have the forms 3508 and 3509, these are the loan forgiveness applications, the loan necessity questionnaires. There's certifications on those too. And those certifications are representations to the government that, if they are false, you could face False Claims Act risk. And at this stage in the process, though, unlike the application stage, if you pay back the loan after learning now that you weren't eligible, or that that forgiveness was denied and you have to pay it back, there's no guarantee under the SBA safe harbors at this stage whether you will be able to escape the risk. So, obviously paying it back is going to help your position with the government if they've alerted you that you weren't eligible for it. But there's not that built-in safe harbor moving down to this stage. So let's go to the next stage. And, fear mongering about False Claims Act risk was not exactly how we wanted to end the webinar. So, let me balance it out with a little bit of reassurance from the DOJ that appears on the screen in front of you. This was from the civil division. That would apply with even more force, of course, to the criminal division, because that's got the beyond a reasonable doubt burden of proof. So, here's DOJ telling us, look, we're not going to be concerned with immaterial or inadvertent technical mistakes. But, as reassuring as this is, the dangers of falling into Paycheck Protection Program related fraud are unfortunately part of human nature sometimes, because, as Benjamin Franklin put it, there is no kind of dishonesty into which otherwise good people more easily and frequently fall than that of defrauding the government. And so there's going to be lots of False Claims Act risk and liability and investigations, to be sure, in the future. And so if we go to the next slide, we'll see some of the action that the DOJ has taken. Throughout 2020, we had lots of criminal charges. Almost 100 individuals were charged for PPP related fraud. This was for using PPP loans to buy Lamborghinis and mansions, the blatant low hanging fruit type of fraud. We had a significant development in January, just of this year, that the Department of Justice entered into a first False Claims Act settlement with a borrower in January. And that was a borrower had applied for a loan, had said that they were not presently in bankruptcy, and yet they were in bankruptcy. And so when the SBA found out about this, they said, well, you got to repay the money. The borrower did not repay the money back right away. And it continued in this limbo for many, many weeks. And eventually the government brought a False Claims Act investigation against and prosecution against this borrower. And there was significant penalties that they incurred through the settlement. So that was ultimately settled, but it shows that DOJ is bringing False Claims Act cases against paycheck protection borrowers. And then even the last couple months, we've seen a lot of MOUs entered into between the Special Inspector General for Pandemic Recovery and the U.S. Attorney's offices all across the nation, trying to coordinate their investigations into this area. So as we look to the future, what do we expect? Well, we expect more False Claims Act investigations, more audits, and that's likely going to be for years to come, because as I said earlier, there's this 6-year requirement to maintain PPP records. And coincidentally, there's about a 6-year statute of limitations for False Claims Act charges. So maybe that's not such a coincidence. Everybody, thank you for participating in this webinar. That's the False Claims Act section, the audit section that I presented on. We're going to segue into questions now. I did receive a question before this webinar by email. And so I thought I would just go into that now, because it was a question about lender liability and lender litigation. And what can lenders do to avoid the risk that's present in these? Because a lot of the presentation is focused on the borrower's risk, and especially my presentation focusing on the borrower risk. But is there really lender liability? Well, fortunately, the SBA regulations have recognized that the lenders can rely on the certifications by the borrowers. If we cut to the chase, though, lenders could still be liable in certain circumstances for a borrower's fraud, concealment, or false statements if the lender had actual knowledge of the fraud, or should have known but recklessly disregarded the fraud, or was willfully blind to the fraud. And in that PPP settlement, False Claims Act settlement that I just described, there was actually a lender that turned the borrower down for the first application, because that lender was the bank, the borrower was a customer of that lender. And that bank the lender knew that the customer was already in bankruptcy. And so the lender said, you don't qualify, I can't do this. Well, that didn't stop the borrower from going to a new lender, actually 2 other lenders, and still applying for the loan through them, where they ultimately got it. So it's those types of situations where the lender liability is greatest. So I've got lots more information to share on this, but I want to toss it back to Jamie and my other colleagues so that we can address some of the questions, at least some of them, on the chat. Thank you very much.
Well, great. We have a lot of great questions that came through on the chat for the panelists. So I'll start with the first one. Is it possible for the SBA to only forgive a portion of the loan? In completing the application, they have not heard back yet, but they feel like they responded where some of it would be forgiven, but not all.
It's our understanding that, yes, that's possible. One of the things that someone else inquired about, from the time you get the SBA decision to when you have to file appeal, is there anything else that could go on there? And one of the things that has been considered by some is that it might be wise to talk to the lender and try to talk to the SBA to see whether there's any middle ground to avoid a battle in the administrative legal process. So technically, it's not in the regs, but that's a possibility. Also, if the SBA reaches out to the borrower, it's kind of like the IRS reaching out to a taxpayer. It might be a good idea to talk, but only with your advisors. And I think Ken is may have seen some of that already, or he's anticipating it.
Great, thank you, Doug. The next question we have is, does a company need to be operating in order to apply for loan forgiveness? If a borrower was to file for bankruptcy protection after the PPP funds were received, can it also apply for and receive forgiveness?
Yeah, I'll take that one on. There's also another question, I believe, that speaks to the bankruptcy question. So a company that has received a PPP loan and then later files for bankruptcy, they're still eligible for loan forgiveness. So you definitely go through that process. Under the round 2 application, there's also a question as to whether the company or 20% or more ownership is involved in a bankruptcy. And FAQs give guidance on what being involved in a bankruptcy is, but if a company is, quote, involved in a bankruptcy or 20% of the ownership is involved, that is a disqualifying fact. So you do have to watch out for that. And also, one of the questions spoke to, what does it mean when a company goes into bankruptcy with a PPP loan? Well, the loan itself is unsecured and it's not supported by any kind of guarantees. So it ends up getting treated like an unsecured loan for purposes of the company. The lender who provided the loan will then in turn around and work with the SBA on the guarantee that backstops that loan.
Great, thanks, Ken. The next question is there anything we should do while we're waiting on an answer for our forgiveness application, or should we simply wait? Doug, do you want to take that one?
Well, I think Ken may need to chime in on this as well. The question is, with whom would you talk at the SBA? You know your lender, and that's what I was touching on before. Talking with the lender, since the lender is supposed to be involved in this forgiveness issue, may be helpful to find out where things are. Ken, any thoughts beyond that?
Yeah, I mean, the lenders are in a similar situation. The latest I've heard is lenders are volleying questions over to the SBA, are receiving answers within 2 to 3 months now of a question. So you can see there's delays across the program. As for borrowers themselves, other than working directly with their lender, where they're in a similar situation when it comes to the communication or lack thereof, there are hotlines, if you go to the SBA's website, to call in, and they're there to answer very basic questions. You know, I think they are helpful to kind of keep the volume of questions coming in down. But if you have a more complicated question or issue that you need to address, I would suggest you work with your legal counsel or your accountants to try to formulate a response in advance of a potential denial by the SBA. That's about as good as you can get for right now.
Yeah, and that's, Jamie, that's what I'd emphasize too. You know, a lot of you are, as the title of this webinar suggested, in this black hole. You just don't know what's going on. But what you can do now is certainly map out your steps for what you're going to do when you get the forgiveness review decision. You know, Doug's talked about the appeals that you may consider and want to go through, and you only have the 30 days to do it. But, you know, for all the borrowers on this webinar, what are you going to do when you get that forgiveness review decision from the SBA? You know, who knows when it's going to happen? It certainly hasn't happened for most within those 90 days, but do you have a decision tree? Do you have in-house counsel, outside counsel? Do you have your, CFO or the folks that have been applying for these loans for your company? Is that decision tree in place so that when you get it, you can immediately act on it and figure out what you're going to do? Because it may be a situation where you don't want to appeal. It may be a situation where you do want to appeal. Hopefully, of course, it's all good news and you don't have to do much of anything except receive all that money that's been forgiven.
Sorry. Go ahead,
Well,
Doug.
I was going to add, there's another black hole in this, and that is trying to figure out how this administrative appeal process is really going to work. During the course of our discussion, I outlined some deadlines and when the SBA has to offer information into the record, what happens after that and what the ALJ can consider from that. But it could be that the borrower might feel that her hands are tied, you really want to put more in there. And so need to consider the briefing that you present to the ALJ, which would seem to me to be mandatory, although that not necessarily discussed in detail in the regs. You have to be able to present your case and the arguments why the SBA made a clear error of law or fact. And as I indicated before, that's pretty broad and hard to figure out what they really mean. But if you can figure out where they made that error, you need to go for it and deep and be prepared well in advance of that deadline.
Okay, great. Another question, and please bear with us. I know we're running a little bit over here, but there's just a few more questions left. If you do not agree with the SBA's decision on non-forgiveness, what is the next step? Does it go straight to legal process, or can you kind of run through the appeals? Doug, I think you may want to take that one.
Well, that's we addressed something similar to that a few minutes ago. You've got that, you get the bad news and you try to figure out what is this all about, at the same time getting ready for this petition that has a 30-day calendar day deadline that you must file. Because as I said, the petition must state in great detail where the SBA went wrong. But it's got to be worth the time to try to figure out with whom you could talk to find out. The final decision that they send could be no explanation, but sorry, we don't forgive any of it. So trying to look at that always makes sense to me in any litigation, to see if there's something that can be worked out. And maybe, just maybe, the borrower might feel, okay, I can understand some of this after I've now heard the story, but maybe we can negotiate so I only have to pay back a certain amount and much less than they're considering. But those are things to be seen in the future.
Great. One of the questions is, if the company is deemed affiliates, but they meet all other requirements, are they entitled to the forgiveness of up to the $10 million on PPP 1? We probably need a little more information on how they're deemed affiliates to really answer that. So if you could follow up with us afterwards, that would be great.
Yeah, I'll speak to that a little bit,
Okay.
Jamie. I mean, the affiliates, the rule is complicated, but if you're deemed an affiliate, the cap is 10 million within the entire group. There are some exceptions, right, for NAIC 72 type entities, that's restaurants, hospitality, et cetera. But if you're finding that you've run the affiliate analysis after the fact and your loans that have been received by the entire group exceed 10 million and you don't otherwise satisfy an exception, that could be a problem.
Well, great. Thank you, Ken. I know we've tried to get to all the questions and we didn't quite get to all of them. So please feel free to reach out to the panelists. Thank you all so much for attending today's presentation. If you do need credit, please complete the sign in to attendance@dorsey.com. And again, any unanswered questions that we didn't get through today, please feel free to reach out to one of the presenters or call on your trusted Dorsey contact. Thank you again so much.